clear as we'd all like it to be. I'd be happy to entertain some discussion or a motion and then discussion, however the board chooses.
Mr. Chairman, I think where I'm struggling, and I'm sure the code enforcement office struggles as well, is that one sentence, each single family lot or attached housing unit. When I picture an attached housing unit, that's an addition onto my existing home.
Sure.
That's attached.
Yep.
Clearly, an ADU, in this particular case, is not attached.
Right, it's not required to be attached anymore.
Yep, it's a single family, it's detached, it's on it could be on another lot, whatever the case might be. So there's where I'm struggling. Having said that, in this particular instance, I'm just wondering if the word attached is where we're getting tripped up.
It is, for me.
For me, it is for me,
Yep.
because this is not an attached unit.
Right, because I think, and this may require some look at a body besides ours, but if you read that without that word, if that were the standard, each single-family lot or housing unit shall have only one driveway curb cut along its street frontage. Mm-hmm. Right, I mean, it definitely, that would make it very clear to me.
Exactly.
But with that word attached in there, somebody was trying to say something.
Yeah.
I don't know what, for sure, but I agree with you. And again, if this is something that they had gone and created a second driveway that wasn't there, created out of whole cloth or good gravel, and then, but I can understand why an applicant would, hey, it's already there, it's cheaper than adding on to the driveway, all I have to do is grade it and pave it. I can see, I can see why they would do that. So I'm not, I'm torn, but I really don't know. Others feel strongly?
Yeah, there's no curb cut because there was no curb.
Correct. And there are probably, and it's not really up to this board to suggest other solutions. It sounds like they've had some discussion with the code office on, or the public works on maybe how to solve that, but that's, I understand why they're here, because the simplest solution is to gain a decision from us that's helpful to them.
Yeah. I think where I'm struggling is, if we were to, and I'm not sure, maybe some guidance from council, if we were to reverse the denial, what the downside is. And I'm not so sure that there's any downside.
Agreed.
There's not a traffic impact, there's not an environmental impact, there's not a safety impact, road construction impact. I mean, it's just another driveway.
Well, so I think that question's a little bit above my pay grade.
Let's do.
I think the thing to keep in mind for this board is that the only reason for denial of this permit, at least it's stated in the notice of denial, is the fact that the code office determined that this was a second curb cut on a single-family lot. It has nothing to do with site distance, doesn't have to do with the standard that the driveway is paved to. I think you can presume, although, Scott could probably confirm this, that the only reason why this, I mean, it would have been stated on the face of the denial if there were other reasons why this driveway couldn't be permitted as it was constructed. So I think that question's a bit, it's outside the scope of what the board is looking at tonight. And to be clear, if you were to reverse the denial, it wouldn't be a guarantee that the driveway permit would be granted, although it appears that, again, this is the only reason why it was denied in the first place, was the curb cut issue. So what would be helpful from my perspective in drafting findings, though, it sounds as if there are a couple bases that the board is looking at in terms of making a decision. You could do this one of two ways, but it's important to be clear about which way or both ways perhaps you're considering. The first is you could grant the appeal by finding that this particular situation, or I'll phrase it a different way, in finding that section 25KA5 that we've been talking about doesn't apply to the situation for one reason or another. That would have nothing to do with how long the tote road has been there, but you could find again, that this is either not a single-family lot, that this is something different, or that perhaps there doesn't qualify as being a second curb cut here because there are no curb cuts. That's ultimately up to the board to sort of craft that decision. Or alternatively, you could find that this section does apply to this lot, but by virtue of how long that tote road had been there, that the nonconformance issue comes into play and essentially sets aside the issue of Section 25K A5.
So in your thought process, because I was just about to ask that, we could find that 25K does in fact apply, but because of the length of time that the tote road existed,
It's grandfathered at that point.
yeah, and I don't know that attorneys hate the word grandfathered, but
It's a term of art. I mean,
It's uncle.
pre-existing, right?
It's uncled.
Yeah, right, it's uncle, there you go.
you're right. You would have to find that if you found that this section applied, then the only way the driveway would be able to continue or be legal
Yeah,
is if you determined that the existence of that curb cut, so to speak, was a legally existing condition on this lot before the ordinance was changed in 2024 to prohibit that. So that's one way that you could grant the appeal. The other way, as we discussed, is simply finding that this section's not applicable. I will say, just from a zoning perspective, typically, if you ask a municipal land use attorney, they'd say that a single-family home with a detached ADU on there, it is still a single-family
Single-family lot.
lot.
I agree.
The ADU is technically an accessory building, and so the classification of that for zoning purposes is still a single-family lot,
agreed.
to the extent that helps.
Hearing that discussion and Mr. Wiseman's thought process, I would definitely entertain a motion along those lines unless there's more discussion.
I make a motion to grant the appeal based on that driveway was there before.
All right, so 25K, if I might, in your motion, 25K does apply, but since
Correct.
there's a unique situation that driveway existed prior to the change in the ordinance, that you would grant the appeal.
Correct.
Okay, so we have a motion?
I'll second it,
Yeah.
but I have a quick question. If you didn't pave it, would Mom still use the dirt road?
Well, Mom's 89 years old, so unlikely, because.
If it wasn't paved, Public Works wouldn't have saw it.
Yeah. For the record, the applicant answered that Mom's 89 and she probably wouldn't use a gravel road.
Yeah, she uses a walker.
Oh, it's, okay.
Yeah.
So rarely any traffic.
No,
So we have a motion and a second. Is there any discussion? Any questions or anything?
Well,
Oh, okay.
yeah, so the other thing is, I would suggest that the code office reached a wrong conclusion because of a lack of understanding of the ordinance.
Okay.
I mean, there is so much confusion, and
Yeah, so I think to pick up where you're leaving off there, you're not necessarily faulting the code officer, you're faulting the code itself because it creates some sort of confusion?
Yeah, that's what I would say too.
Yeah.
But that's not up to
Right,
us
it's
to
not really up to us,
decide.
but it's more of a comment along those lines that, and it sounds like they're working on this as we speak anyway.
I was going to say,
Yeah.
if I may, Mr. Chairman, it sounds to me as if there's a systemic issue here, Scott, where we have code and public works kind of driving the same bus.
Yep.
And I think that's where the discussion needs to lead.
And I think we're going to hit some clarification eventually with that. Any further discussion? To be clear, a vote positively grants the motion, grants the appeal.
Correct, would grant
way the motion was
would grant
written,
the appeal
you
and
vote for
reverse,
it?
and reverse the decision of
Okay.
the code office. Yes.
All in favor? 2, 3, 4, 5. There you go. None opposed? You got it all right? So,
Some of it written up. I also don't have a way to get, well, someone I'm sure can give me a Wi-Fi password if
yeah,
I need to,
Nina
but
can probably help with that. So why don't we take a short recess while you write that up? And then, if that's okay, I mean, rather than make the board all come back and and that kind of thing. So,
yeah.
motion for a
Makes it cleaner.
5-minute recess?
Sure.
Seconded? Yep, there we go. All in favor? 5-minute recess? Thank you. I don't think so.
Oh, yeah. You-
All right, so we're
You couldn't spend it faster.
back in session, gentlemen. During the break, we had the attorney write the findings that this board found. We're going to have the attorney read them out loud, and then we will see them in writing as well. So at this point, if you'd like to take it away.
Sure. So this is a notice of decision from the Town of Gorham, Maine Board of Appeals, Appeal 25-01. I'll start. Dear applicant, which is what it says at the top, this is to inform you that the Town of Gorham Board of Appeals acted on your application for an administrative appeal at its meeting on February 20th, 2025, and made the following findings of fact and conclusions of law. I'm going to read all of the findings. I'm going to read and then pause, and if there are changes that anyone on the board would like to have made to those as I'm reading them, please let me know, and then you'll have a final vote at the end. So, findings of fact. Number one, the owner of the property and applicant for this administrative appeal is Heidi Young Real Estate, LLC. Two, the property associated with this appeal is located at 59 Buck Street and is identified as Assessor's Tax Map 76, Lot 42-102. The property is located in the Suburban Residential District under the Town of Gorham Land Use and Development Code. The property is 2.04 acres in size. 3, the owner has demonstrated a legal interest in the property by providing a copy of a deed dated March 8th, 2023 from K&H Property Management Development, LLC to Heidi Young Real Estate, LLC, recorded at the Cumberland County Registry of Deeds in Book 40036, page 117. And that was in your packets tonight. Number 4, the property is Lot 2, as shown on the subdivision plan of JDP Estates, approved by the Gorham Planning Board on December 5th, 2022, and recorded in the Cumberland County Registry of Deeds in Plan Book 223, page 3. There's those.
Thank you.
Number 5, thank you. The property contains a single-family home. In addition, the owner has received approval from the Gorham Code Enforcement Office to construct a detached accessory dwelling unit on the property. Number 6, on December 2nd, 2024, the owner submitted a driveway permit application to the Code Enforcement Office seeking permission to construct a second driveway from Buck Street to the property in order to provide exclusive access for the ADU. The application was submitted after completion of this driveway due to a misunderstanding between the applicant and the Code Enforcement Office. Number 7, on December 16th, 2024, the Code Enforcement Office denied the application as the same was found to not comply with the requirements of Section 2-5KA5 of the LUDC. Section 25KA5 of the LUDC provides, quote, each single-family lot or attached housing unit shall only have one driveway curb cut along its street frontage. 9, this section of the LUDC was enacted by the Town Council on May 7th, 2024. 10, Section 1-2(1) of the LUDC provides, quote, any lawful use of buildings, structures, premises, land, or parts thereof existing at the effective date of this code and made nonconforming by the provisions of this chapter or any amendments thereto may be continued subject to the provisions of this section. 11, prior to submitting the application, the property had an existing permitted curb cut and driveway providing access from Buck Street to the single-family home located on the property. 12, the property's legal street frontage is provided by Buck Street. 13, the board held a public hearing on February 20th, 2025 with 5 board members present: Mark Curtis, Gary Baca, Dan Nichols, Craig Sterling, and Michael Weissman. 14, the applicant appeared through its members, Kevin Young and Heidi Young, who offer testimony on behalf of the applicant. 15, the applicant's testimony including the following information regarding the property. A, since at least 1998, the property has contained a gravel logging road. That logging road is accessed via a curb cut onto the property from Buck Street. B, prior to the denial of the application, the applicant was under the impression that there would be no issue with utilizing this gravel logging road as a second driveway on the property for providing access to the permitted ADU. 16, the code enforcement officer, Scott Dvorak, testified that he did not have any concerns with the safety or other aspects of future use of the gravel logging road for driveway purposes, but was only aware that the gravel logging road had been paved for use as a driveway after it had occurred. 17, no other individuals testified in favor or in opposition to the appeal. Any changes, any additions, anything whatsoever?
Nope,
Okay.
seemed great to me.
That leads to conclusions of law. There's only 4. First is jurisdiction. The board has jurisdiction to hear this appeal pursuant to section 1-4B1 of the LUDC, as this appeal is from a decision of the code enforcement officer. 2, timeliness. The applicant's appeal is timely as it was filed on January 14th, 2025, which was within 30 days of the code enforcement officer's decision as required by section 14D1 of the LUDC. 3, standing. The applicant has standing to bring this appeal pursuant to section 14D1 of the LUDC as it is both the property as it, and it is an LLC, which is why that word is used, is both the property's owner and a sufficiently aggrieved party in relation to the code enforcement officer's decision. And then 4, second driveway use. This is where the rubber hits the road. The applicant has demonstrated through substantial evidence in the administrative record that the gravel logging road on the property was legally in existence prior to the adoption of section 2-5 KA5 of, that should be LUDC and not code.
I'll make that change.
And was therefore a legally non-conforming condition on the property. Under section 1-21 of the code, this gravel logging road and its curb cut may continue to exist and be used, notwithstanding any other portion of the LUDC to the contrary, provided that its construction meets all the requirements to receive a driveway permit. As a result, despite section 2-5 KA5 of the LUDC applying to the property, the code enforcement office's decision to deny the application was in error. So based on the above findings of fact and conclusions of law, the Board of Appeals voted 5 in favor and none opposed to grant your application, because again, this is directed to the applicant, for an administrative appeal as you have met your burden of proof to show that the Code Enforcement Office misinterpreted the LUDC in denying your application for a driveway permit for 59 Buck Street. This notice of decision is adopted by the Board of Appeals, which has authorized its chair to sign the same on behalf of the board. And then there's a signature line for Mark, and then at the last page, in all bold, reminding that any party aggrieved by this decision may file an appeal in the Superior Court within 45 days of the date of this appeal, consistent with Rule 80B of the main rules of civil procedure.
Thank you.
It.
Any corrections, any adjustments by anybody?
No, I would just comment, thank you for delineating all those points numerically in simple, itemized fashion. That was great.
I think that's the most thorough version of finding of facts I've seen since I've been sitting in this chair. Thank you. At this point, a motion to accept those findings of facts?
So moved.
Second?
Second by Gary. Any discussion? All in favor? 1, 2, 3, 4, 5. We are good to go. Next motion is to adjourn.
So moved.
Second by Gary. All in favor? And we are adjourned.